A successful divorce settlement is a result of putting the pieces of the puzzle together in such a manner that both divorcing parties come out of the divorce whole, or at least on a strong road to recovery. But how do we get there? It all begins with assembling a solid divorce team consisting of professionals who understand the value of proactive communication with each other on behalf of the divorcing spouses. I like using this image of a puzzle because it not only shows how these four pieces of the divorce puzzle fit together, but it is also a great reminder of how disconnected they are as well. And it is the disconnect that we need to be most concerned about. Divorce and mortgage financing issues are often a touchy subject in divorce situations, particularly when one spouse is dependent upon income awarded from the divorce for mortgage qualifying purposes, and also when contingent liabilities are present, such as a jointly held mortgage on the marital home. Having a basic understanding of how lenders look at various aspects of divorce can have a significant impact on divorce negotiations. I'd like to take a moment to properly introduce myself. My name is Jason Gordon, and I have originated residential mortgage loans since 1999, which means that I assist home buyers to obtain financing to purchase their homes, along with homeowners with refinancing needs for various purposes. Although the majority of my business does not involve divorce, I have a unique specialization in assisting divorcing homeowners and divorce attorneys to help them determine if one spouse can successfully retain the marital home via an equity buyout to the departing spouse. So let's take a moment to acknowledge the elephant in the room. Nowadays, we must be very careful when we communicate. Any ambiguity can and will be used against us in the court of public opinion. That said, I would like to proactively provide clarity. All members of my team, including myself, absolutely respect the sanctity of marriage. None of us are celebrating divorce, and we are certainly not breaking up marriages in order to generate a commission. The fact of the matter is divorcing homeowners deserve to be better served than the status quo. I truly believe that divorcing homeowners are being underserved by both the real estate and mortgage industries as a whole. The intersection between divorce law, tax law, real estate, and mortgage financing is real, and we cannot ignore it. Factor in the added emotional complexities present, and you simply cannot think traditionally when working with divorcing homeowners. It bears noting that I have received and continue to receive high-level training on these topics. I am currently the only person who has ever earned all of the following credentials. Certified Divorce Lending Professional, also known as CDLP, which in my opinion is the highest level training available on this topic for mortgage professionals. A Certified Divorce Real Estate Expert, also known as CDRE, which in my opinion is the highest level training available on this topic for real estate professionals. Certified Divorce Specialist, also known as CDS, which is a strong training to integrate additional members of the divorce team into collaborative approaches to assist our mutual clients. And lastly, Real Estate Collaboration Specialist in Divorce, also known as rcs-d, which was taught by a law school professor. While I do not claim to know it all about this topic, I am definitely all in to assist this population at the highest levels of ethics and competence. So thank you very much for your attention today. I hope you gain significant value from the content. I'd like to explain what divorce mortgage planning is and the value of having a certified divorce lending professional, also known as a CDLP, on your divorce team during the settlement process. Divorce mortgage planning is an overall holistic approach to the process of evaluating mortgage options in the context of financial objectives as they relate to divorcing situations. The role of a CDLP is to help integrate the mortgage selected into the overall short-term and long-term financial and investment goals to help minimize taxes, minimize interest expenses, and maximize cash flow. Our mission is to help divorcing homeowners make more informed decisions regarding their home equity solutions and mortgage financing opportunities both during and after the divorce. And I want to make something very clear. A CDLP never gives legal or tax advice. Only about 70% of what a CDLP does actually involves mortgages. The remaining 30% is split between working with the divorce team during the settlement process and gaining valuable insight as to the specific financial, tax, and legal goals of our mutual client. It's that holistic approach in being able to think outside of the box that gives the CDLP a different perspective of the entire divorce file and ultimately helps to provide better solutions to everyone involved. So how can a CDLP help you? As a divorce mortgage planner, a CDLP can help you identify any potential conflicts between the divorce settlement agreement as they relate to financial planning, home equity solutions, and/or any real property issues involved in your case. For example, the verbiage in the divorce settlement agreement as it relates to structure of support income and/or division of assets, as well as certain aspects of the real property itself, can directly impact the ability to obtain mortgage financing. And to put that a different way, the mortgage option chosen can have a direct impact on any financial and/or tax planning set up during the divorce process as well. When any borrower applies for a mortgage loan, one of the largest areas of scrutiny to determine if they will be approved is the debt-to-income ratio. This measures cash flow. So therefore, in order for a lender to properly calculate the debt-to-income ratio, the lender must first determine what income can be used on the application. A big takeaway here is that not all income that's actually received is guaranteed to be considered qualifying income on a mortgage loan application. This is one of the largest hurdles that we face when working with divorcing clients. So I wanted to give you a bit of insight as to what goes on behind those calculations. When working with divorcing clients on mortgage financing, we have certain requirements that we have to meet in order to determine if that income source will be considered qualifying income. And it actually must pass two different tests: stability and consistency. It's also one of the hardest guidelines for a client to understand, and it creates a lot of frustration when they really do have sufficient income coming in every month, but we lenders are not giving them credit for all that income on the application. We may be dealing with prolonged employment gaps if one of the spouses has stayed home as the primary caregiver for more than 6 months. Any type of support income has to meet its own different tests for use, even down to the name. Yes, alimony, maintenance, child support, spousal support can be treated differently, believe it or not. So it's very important that the CDLP get involved during the settlement process to help provide intel to the divorcing homeowners and any representatives that they may have legally and/or financially to determine if there's a better way to structure those settlement payments in order to qualify for a mortgage loan. We see a lot of divorces that involve lump sum payments instead of monthly support payments. While that may seem like a good thing to have a very large amount of money in the bank, it may not bode well for debt-to-income ratio purposes on a loan application. As a CDLP, I am trained to work with a divorce team to come up with solutions proactively for all different types of income sources. Let's examine some of the common issues related to support income. In this case, the same requirements are in place for both spousal support as well as child support. The basic guideline is often referred to as the 636 rule. In order for spousal and/or child support to be considered as qualified income, we typically need to show at least 6 months of historical receipt combined with at least 36 months of future continuance after the loan has funded. The problem can arise when, say, for example, spousal support is awarded for a total of 3 years. By the time we could show the 6 months of historical receipt, we no longer have the 36 months of continuance into the future and therefore will not be able to use this income as qualified income. The same rule applies to child support for both proof of receipt and continuance. An example of one of the more difficult dynamics that we come across with child support is that many settlement agreements provide for a lump sum of child support from the payor to the payee. And let's say that there are two children, ages 12 and 16, and child support ends when each child turns 18. We have, in this case, the older child aging out before we have the 36 months continuance. Yet we have no way of distinguishing how much of the child support in total is going to be given to each child, and therefore we have to make a judgment call. It's not a good idea to have banks make a judgment call because sometimes we're going to use little or no income, where if it had been clarified in the settlement agreement, we could have used a lot more income. Another hurdle we face with support income, other than meeting the 636 rule, is documentation and receipt guidelines. We have to meet two specific criteria in order to use support income in addition to the 636 rule. In order for support income to be usable, it has to meet our standards of both consistency and stability. Basically meaning it has to be paid as ordered. So if the order says that spouse A is required to pay $1,000 in spousal support to spouse B by the 5th of every month, and spouse A pays the $1,000 in various amounts throughout the month, there's going to be an issue using that support as qualifying income. Now let's discuss documentation. In documenting the 6 months receipt, we need to establish a paper trail. We either need to show copies of the check deposited, which is typically easier. However, most parties now transfer those funds electronically. Sounds pretty clean, right? The hard part is that we have to provide proof that the party transferring the money is indeed the former spouse, which requires that we show ownership of the bank account where the money is coming from. Now, how many ex-spouses do you know that are willing to provide a copy of their current bank statement? This can cause problems. And by the way, we do not need a current bank statement. It can be one that was used during the discovery phase. All we need to verify is the name and the account number. We see a lot of ex-spouses who have an issue with transferring money from their personal account directly to the receiving spouse's individual account. So oftentimes between the couple, they agree to transfer the money to a joint account in both of their names, and then the receiving spouse transfers the money from the joint account into his or her own individual account. Unfortunately, in this case, that income cannot be used as qualified income because you cannot pay yourself support. And effectively, that's what's happening here. And another situation to be aware of is what we call netting out the support payments. Let me give you an example. I spoke to an attorney recently on this very situation. The husband, during temporary orders, was ordered to pay the wife $9,500 in monthly support. However, out of that $9,500, he was to pay the mortgage, utilities, and medical expenses directly, and then pay her the remainder in cash. She was supposed to refinance within a certain time frame once that divorce is final and use that income as qualified income. However, we cannot use that income received during temporary orders because it does not meet our requirements for stability and consistency. If you are ever in the situation with one of your cases, it's cleaner and easier to pay the full amount to the receiving spouse and then have the receiving spouse pay the bills directly for loan qualifying purposes. So again, when we have the opportunity to set the expectations to each spouse on what is required up front, we can all be that much more successful in the end. An issue that comes up quite frequently in regards to spousal support is the lump sum payment in lieu of monthly payments. Let's say, for example, that he has agreed to pay her $500,000 in total spousal support. However, instead of paying her a monthly allotment over a certain period of years, he has opted to pay her the entire $500,000 in one lump sum payment. From a life perspective, this kind of makes sense and seems like a good thing for her. From a loan perspective, this can be very problematic for her if she intends to pursue any mortgage financing in the near future. Now, that financing that she might want to pursue could be purchasing a new home, or she may have a court order that requires her to refinance the marital home into her name within a certain period of time. Let's say, for example, that she's not currently employed. If she's not receiving monthly spousal support, she has zero qualifying income, and is going to have a very difficult time qualifying for a mortgage loan anytime soon. Now, it bears noting in this particular case, I might be able to use some of that money to convert it into trust income and therefore be qualifying income on a loan application, but it's not a given. The key takeaway here is that as professionals assisting divorcing homeowners, we need to collectively take into consideration what the mortgage financing needs are for our clients before we let them accept any kind of settlement that requires mortgage financing be obtained anytime in the near future. Only when we are working together during the process can we proactively assist. We cannot do anything once the divorce is finalized. At that point, we are forced to deal with the cards that are dealt. As I mentioned earlier, lenders use a calculation called a debt-to-income ratio when measuring cash flow. So therefore, it is also very important that we account for the appropriate debts in order to make that calculation. In divorce, we oftentimes come across division of existing debts. When one party is ordered to make the payment on a specific debt, it is referred to as a court-ordered assignment of debt, also known as a contingent liability. Let's say, for example, that he and she are jointly responsible for the mortgage on the marital home. She is the in-spouse. She plans on staying in the home. He is the out-spouse. He plans on moving out of the home. However, there are no plans on refinancing the joint debt, but she is to take over the payments on that joint debt and take full responsibility of the debt. In order for that debt not to count against him in his debt-to-income ratio calculations, specific verbiage is needed on the marital settlement agreement. Now, the same goes for sharing of joint debt. If it's going to be shared between the spouses until it's paid off, then it needs to be specific as to how the payment is going to be made. If it's not clarified specifically that the spouses will both pay, let's say, 50% of the monthly payment until the debt is paid off, then each spouse is going to be hit for 100% of the payment on each of their mortgage applications. The same goes for student loans. I cannot stress enough how important clarity is and how the verbiage used can make or break mortgage financing. Now, on a side note, this entire slide refers to joint debt and excluding debt from debt-to-income ratio calculations. In the example I gave, even though she has a court order to absorb that mortgage debt, should she fail to make payments on time, the existing creditor will report the late payment to both of their credit reports. So now let's talk about the actual house itself, which is typically one of, if not the largest marital asset. The two most common ways to deal with the marital home are either for one party to retain the home and pay the other party their share of equity by refinancing the current mortgage, or the parties may choose to sell the home and split the net proceeds. When one spouse is retaining the marital home and acquiring the ownership interest of the other spouse by paying them their share of equity through a refinance, it is referred to as an equity buyout. This term confuses many into thinking it is a purchase loan when it's not. It is a refinance. Now, just because the court may order one party to refinance the current mortgage, the court cannot dictate what type of loan the party can use. Yes, it may be a refinance, but there are two different categories of refinances. There's rate and term, and there's cash out. Again, the verbiage in the settlement agreement needs to be specific, but there can be certain aspects of the real property that can also trigger the use of a cash out refinance over a rate and term refinance. So what's the big deal? Well, rate and term refinances provide better financing terms as opposed to cash out, and rate and term also allows you to access higher amounts of equity in the property, which is often the goal of an equity buyout. So if we are forced to use a cash out mortgage, not only does it carry higher mortgage rates, it usually allows only 80% of the value of the home to be accessed. So what if the spouses currently have 30% equity in the home and the vacating spouse is awarded 15% of that equity? The retaining spouse can only access 10% of that equity on a cash out refinance because, again, they are limited to 80% loan to value. And the same thing for the vacating spouse who might want to purchase a new home. The verbiage on the settlement agreement can kill mortgage financing. So again, having a knowledgeable CDLP on your team can help make the divorce much more successful for both spouses. Let's take a closer look at the underwriting guidelines of the equity buyout, because quite frankly, most divorcing parties and most divorce professionals do not understand these guidelines. And the failure to understand these guidelines can cause issues complying with court orders. Obviously, our goal is to be able to classify the refinance as rate and term, but there are specific requirements that must be addressed in the marital settlement agreement, or MSA, in order to make that happen. This goes back to the court-ordered assignment of debt that I previously discussed and the verbiage used. Not only does wording in the MSA affect how the debt is omitted from the non-paying spouse, but it can also directly impact the classification of the refinance. In order for an equity buyout to be classified as a rate and term refinance, it must meet the following requirements. The equity buyout must be addressed in either the homestead or real estate section of the MSA, basically meaning it has to be addressed independently. It cannot be included in, say, an addendum that identifies all the marital assets, and then the equity distribution is absorbed into the total division of the marital estate. It must be addressed separately. Absolutely no cash back is allowed to the borrower for debt consolidation, attorney fees, etc. Literally not 1 penny can be due to the borrower at closing. And the borrowing spouse must have been on title for the previous 12 months. Now, this is a key factor if, for example, the mortgage and title was held in, say, the husband's name, and the wife is now awarded the marital home and needs to refinance the mortgage. Even though the court order makes her a successor of interest, which then does allow her to refinance the home, even though she's not on the current mortgage, it does not allow her to access a rate and term program. Again, the court cannot dictate which category of refinance is applicable in this case. Let's address the actual equity buyout court order itself. This is another area that can be very distinct in each case. Typically, the dollar amount of the equity share to be paid is written as a percentage of the appraised value. Other times, it's written as a specific dollar amount, and sometimes it could be a combination of the two. For example, he is to receive 50% of the equity in the marital home, or no less than $50,000. When a specific dollar amount is referenced, rather than a percentage of equity, there is potential for unpleasant issues. Let's say, for example, the divorcing couple has an appraisal done on their home independently before beginning the loan application. Based on that appraisal, they determine that he is entitled to a $60,000 equity share. Then they apply for the mortgage. And when the CDLP orders the lender's appraisal during the refinance process, wouldn't you know it, the value comes in lower than the original appraisal. The lender cannot use the original appraisal. They must use their own independent lender-initiated appraisal. This is a federal guideline called the Home Valuation Code of Conduct, also known as HVCC. This is not a lender-specific guideline. This dynamic can obviously cause issues if the appraisal amounts do not match. Another element to consider is a realistic time frame for refinancing. When we go back to the previous conversations we had about various types of income calculations, divisions of debt, the rule of 636, we know that timelines can be very sensitive towards mortgage approval. Now, what if the marital home ends up being sold and one or both of the divorcing parties are planning on buying a new home secured by brand new mortgage debt? Those guidelines still apply even for the brand new mortgage. Now, if neither were able to qualify for mortgage financing because certain things were not discussed or clarified before the divorce was finalized, it's probably not going to blow back on anyone in terms of any malpractice or anyone crying foul. But isn't it our duty as divorce professionals to take into consideration the future plans of our clients and address all these issues we've gone over today proactively with them? We want to make sure that these parties are set up for success post-decree. There's also one more factor that should not be overlooked, whether the existing mortgage is refinanced or the property is sold. Either way, we have to address how any escrow or impound account or overpayment refunds from the existing lender are going to be shared. If the mortgage is held jointly or in the name of one spouse, it doesn't matter how the settlement agreement disposes of the marital home the existing lender is going to issue that refund check in the name or names of the existing borrower or borrowers. It needs to be addressed how this refund will be split and or who gets to receive it. Remember also that in most areas, property taxes are paid in arrears, so the amount in the current escrow account is actually there to pay an existing tax liability associated with the marital home or other real estate. I would like to now take a moment to tie all this information together in a sample case study. This case study includes many of the common issues that we see dealt with during the normal divorce settlement process and how it can make obtaining mortgage financing a challenge. Please remember, mortgage guidelines are constantly changing. They could be different on any given day, in any given state, with any given lender. Please always make a point to consult a local CDLP before structuring your settlement agreement if mortgage financing is a goal. In this example, the wife is awarded the marital home, and she is to refinance the current loans into her name within 120 days of the divorce being finalized. The husband is going to receive his equity share of $111,500 upon refinance based on the current divorce appraisal that they obtained independently. The wife is to be given $500,000 from the husband's 401k via a qualified domestic relations order, also known as a quadro. The joint marital debt of $8,000 owed to the existing Visa card is to be paid by the wife out of the equity in the marital home. The joint marital debt of $30,000 to an existing American Express card is to be paid by both parties until the debt is paid in full. The husband is to pay $1,200 in monthly spousal support for life. The husband is to pay child support of $800 per month until their child turns 18, 2 years from now. The CDLP Divorce Mortgage Planning and Real Property Report is one of the many tools that I personally use, which can provide a huge wealth of information that is not only important for the mortgage aspects of the divorce, but it also provides the rest of the divorce team with valuable and necessary data needed for the case as well. As part of this case study, we are putting this report together for Jane. She is seeking to retain the marital home and needs to refinance the existing mortgage into her name. The real property details portion highlights significant information for all of us. We can see that title is held by both spouses, and that our borrowing spouse, Jane, has indeed been on title for at least 12 months. This means no title issues for the mortgage. Next, we have the property valuation section, which obviously highlights the lender's appraiser's opinions of both value and available equity in the property. How about a glance at the property insurance information? We can see that only the husband, John, is listed as the insured party on the existing policy. If John is vacating the property once the divorce is final, yet before Jane has had an opportunity to refinance, someone needs to review the policy to make sure there is no lapse in current coverage. Next, we have a current overview of the mortgage situation. 2 mortgages currently exist, a first and a second. The mortgages are both in the husband John's name only, which is not necessarily an issue for our borrowing spouse Jane because she becomes the successor of interest. However, there are 2 items that I do want to point out here. There is a current escrow or impound account balance of $9,500. Even though the wife Jane is awarded the marital home, all refunds due to overpayment of an escrow balance are paid directly to the mortgagee. In this case, the $9,500 is going to be paid directly to John, not to Jane. And also you can see that we have an open and active home equity line of credit, also known as a HELOC. Until this loan is paid and closed, or until John reaches out to the existing bank to freeze access of the HELOC from further use, John has legal access to any available funds on this HELOC. If John accesses any of the additional funds before Jane completes her refinance, it can significantly impact not only the equity available, but her ability to obtain mortgage financing. So now let's see how all this information ties together for Jane's mortgage financing options. Loan scenario number 1 is written exactly how it was structured in the marital settlement agreement of this particular case study. Specifically, the equity buyout of $111,500 to John and the $8,000 Visa card that Jane will pay through the loan at closing. Remember, if Jane takes out any cash other than to satisfy the actual equity buyout, the mortgage refinance is classified as cash out and will limit our access to 80% of the home's appraised value. In this scenario, we are at 87% loan to value, and unfortunately, the way the settlement agreement was put together does not meet the guidelines for mortgage financing approvability and will not work. Let's look at loan scenario number 2. If Jane still does pay the $8,000 Visa card through the proceeds of the loan as ordered, we still do have to work with the cash out equity limitations of 80% loan to value. In this case, she can only access $60,000 of equity to pay John, which will leave her with a shortage of $51,500. Now let's look at loan scenario number 3. What if we do pay John the full $111,500 through the refinance, but we do not address the $8,000 Visa payoff through the close of this escrow, and instead we get creative? What if we award the escrow refund of $9,500 directly to Jane, and she uses that money to pay the Visa card outside of the refinance? It actually makes sense anyway. Remember that in most jurisdictions, property taxes are paid in arrears or from behind, meaning that we're paying last year's property taxes in the current year. When Jane refinances the marital home, she will likely establish a brand new escrow account and fund that account with enough money to pay future property taxes when they ultimately become due. And in reality, the current escrow account is there to pay an existing tax liability that is shared by both spouses. So really, why should that money go directly to John anyway? I'll tell you that in all of the divorce filings that I personally review, the current escrow balance is almost never addressed. And I've seen some pretty hot debates over who is entitled to those funds when that escrow check is ultimately received just a few weeks after the existing loan is paid off. And as you can see, those checks can be pretty hefty. We have yet to determine whether or not Jane can qualify for this mortgage equity buyout refinance from the perspective of a debt-to-income ratio, which seeks to measure monthly cash flow. As you can see, this portion of the spreadsheet takes a closer look at both the qualifying income as well as the debts needed in order to calculate this debt-to-income ratio. Taking a closer look at support income. At this time, unfortunately, neither the spousal support or child support that was ordered can be used as qualifying income. Remember the rule of 636 that was discussed earlier. With regards to spousal support, we only have 120 days, which is 4 months, of historical receipt, and therefore do not meet the required 6 months. In regards to child support, it is due to end in 2 years, and therefore does not meet the required 36 months of future continuance in order to be counted as qualifying income. Unfortunately, neither income can be used at this time. And as a reminder, the American Express debt that both parties agreed to share 50% each until it's paid off in full needs to be clarified on the marital settlement agreement in order to not hit Jane with the full monthly payment on her loan application. In looking at these numbers, it is easy to determine that there is not enough income for Jane to qualify for mortgage financing. So what are our options since we only have a time period of 120 days in order to make this happen per the court order? So as a CDLP, how can I utilize creative financing techniques to overcome the debt-to-income ratio challenges on behalf of my client Jane to help her fulfill her goal of retaining the marital home? Remember that Jane is due to receive $500,000 from John via a quadro. There is a way to utilize that extra money in the bank to convert it to qualifying income for debt-to-income ratio purposes. Let's say, for example, that Jane needs to show an additional $2,500 in monthly income to qualify for the equity buyout refinance. We would need that income source to last for a minimum of 3 years from the date of funding. So let's do the math. $2,500 times 36 months equals $90,000. One option might be to establish a revocable living trust as part of the settlement. Since we now have $500,000 due to Jane, we can take, say, the first $100,000 from the Quadro to fund the trust up front. This creates the monthly distribution of the required $2,500 with a few months to spare. Now, why might this be a solid option? Because when it comes to evidence of receipt of income for trust income, we only need 1 month proof of receipt, as opposed to the required 6 months of historical receipt for child support and spousal support income. This allows us to meet the 120-day deadline of the court order. Again, it is important to work with a trained CDLP in this type of situation because the CDLP needs to work with the divorce team to make sure that the specific items are handled in a specific order when notating the specific verbiage used in the marital settlement agreement. The value that a CDLP brings to your divorce team and the mortgage planning aspect of the overall divorce settlement is huge. If we are truly dedicated to assisting our divorcing clients, we need to work together and address the overall home equity solutions of these divorcing parties. This will allow us to make the divorce settlement as successful as possible. You cannot think traditionally on the topic of mortgage financing when combining it with the complexities of divorce. There is one last issue that I would like to address, and that is how a CDLP gets compensated. First of all, marital status is a protected class according to the Federal Trade Commission and the Equal Credit Opportunity Act. Disparate treatment is when a lender treats applicants differently based on a prohibited factor such as marital status. A CDLP is not allowed to charge a fee for their services. The CDLP is there to consult with the divorce team and the divorcing homeowners, and then we hope to be able to facilitate the required mortgage financing, whether that be refinancing the marital home and or purchasing a brand new property, which at that point we are compensated by the mortgage company by whom we are employed. There are CDLPs across the country, all of whom are trained by the Divorce Lending Association on an ongoing basis. Remember that a successful divorce settlement is a result of putting the pieces of the puzzle together in such a manner that both divorcing parties come out of the divorce whole, or at least on the road to recovery. A certified divorce lending professional has a completely different perspective on the overall divorce file and is typically able to provide much better solutions to everyone involved. This concludes today's presentation. I would like to sincerely thank all of you for your time and attention. I'd also like to thank the Divorce Lending Association for their permission in sharing this content with you today. My name is Jason Gordon. My website is divorceloanpro.com. My NMLS ID is 259027.